Good morning to everyone at today's public hearing of the Vetting Commission established under Law Number 65 of the year 2023 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of Panel B of the Commission, and I declare this session open. The hearing is being conducted under Law Number 252 of the year 2023 on the external evaluation of judges and prosecutors and amending some normative acts, and also under the Commission's Rules of Organization and Functioning. The subject of today's hearing is Victoria Sîrbu, a judge of the Central Court of Appeal, previously the Chișinău Court of Appeal. Judge Sîrbu, good morning.
Bună dimineața.
I'm joined by two other panel members. To my right is Commission Member Willem Brouwer, and to my left is Commission Member Iurie Gațcan. The panel is also assisted by members of its secretariat, and you may notice some members of the public or the media in the audience. The photographer will take pictures briefly just at the outset of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Only one person should speak at a time. The proceedings are being recorded. The recordings of the public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days after the hearing. During the hearing, one or more members of the panel may ask you questions. Please answer them truthfully and completely. Your answers are important to the panel in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will take into account your privacy and, where required and possible, the privacy of family members and close persons. We'll omit unnecessary details such as ID numbers, specific residence addresses, and so forth. For the protection of privacy, we ask you to do the same. I will briefly review the evaluation process for Judge Sîrbu. The Commission began its evaluation on April 11th, 2024 by notifying the judge by email and asking her to complete and return an ethics questionnaire and the declarations required by Law Number 252. The judge returned the completed documents and questionnaire on the 30th of April, 2024. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. Over the months September through December of last year, we asked the judge 4 rounds of questions to clarify certain matters. The judge provided additional answers and information during that period. On January 24th, 2025, we notified Judge Sîrbu that the panel had identified some areas of doubt about her compliance with the ethical criteria and invited her to attend today's hearing. On January 29th, Judge Sîrbu asked for access to the evaluation file. The Secretariat of the Commission provided access to those materials on January 31st. Judge Sîrbu, do you wish to make any corrections or additions to the answers you've provided to the Commission's prior requests for information?
With regards to the request of information, I declare that I don't have anything to add, and I confirm everything I have reported so far.
Similarly, are the answers that you provided on April 30th of 2024 to the ethics questionnaire and the declaration statement, are they still accurate as of today?
Of course.
Okay. We'll now ask some additional questions. As you know, one of the areas of concern mentioned in the hearing notice concerns a case that ultimately resulted in a decision by the European Court of Human Rights, the Bezdiga case. Is that how you say the name? And the ECHR ultimately found a violation of Article 8 of the European Convention of Human Rights related to the process by which the father's visitation rights with regard to the child were established. I'm going to ask some questions about that. The European Court of Human Rights in its decision observed that it believed that allegations of domestic violence were central to the determination of the father's contract rights, and that the file did not reflect that the domestic courts had considered those allegations in the assessment. And I would invite you to comment on that. You have in your written answers, but if you want to say anything more, I'd like to hear your thoughts.
Dear Chairperson, dear members of the Commission, I will be explaining very briefly some aspects with regard to this case. Indeed, I took part in this case. I didn't take part, I took part as a member of the board.
Mrs. Sîrbu, would you slow down for the translator?
Yes, and just so we're all clear on the timetable, the father, Vadim Vizdiga, he filed his appeal on September 21st of 2017, and we see from the case file that the Court of Appeals issued its opinion less than 6 weeks later on November 1st of 2017, and you were saying you were a member of the panel, correct?
That's correct.
And I know that in your written answers you observed that in the appeal you did not see an issue was not presented regarding domestic violence.
Here I would like to highlight that indeed this respective case has been distributed on 12 September 2017, and the reporting judge, with expeditiously, only in 3 days, issued a decision without considering the appeals court decisions. But we need to have a reasoned motivation, and the person on 25 October 2017, that appeal has been pending already, and in 1 week time, the decision has been issued. Even in the findings of the ECHR, they found that this case at the national level has been examined within 13 months, and the court said that was a very reasonable time frame. With regard to our timeline, on the date of issuing that specific decision, that timeline actually, the deadline was until 31 October. And that timeline didn't have any effect because it was ended, terminated by that time.
Right, and just so people understand what we're talking about here, the father was challenging a schedule that had been set by the Social Assistance and Family Protection Directorate. It was a schedule for visiting his child twice a week, but it was a schedule that had only been set for 1 year, and after that year it was subject to his asking for further changes. And I think what you're saying is, on the date that the Court of Appeals issued its decision, that schedule was open to revision. So his challenge, in effect, wouldn't change anything. Am I understanding you correctly?
That's correct, and I would like to point out that ECHR said very clearly that that process has been void of any goal with regard to reasonability and equitability. I talked about the duration of the case. It should be clear that on the appeals court, this case has been pending from 12 September 2017, we worked expeditiously on this case. On the date of termination, we had an administrative act which has been consumed, and the legislator says that this type of act cannot be annulled or overturned because it has no effect. What was the rationale to administer an act which was consumed, terminated? And here I would like to point out that when we have examined that case in 2017, nobody from the participants in the process did not invoke any aspects related to domestic violence. I have read carefully the decision of the first court. I also studied the decision of the Chișinău Court, including the transcripts, and therefore in this transcript I didn't find any aspect related to domestic violence. It is supposed, and the ECHR says also that the courts admitted this argument, but on the date of examination we couldn't even debate those arguments because it was an act that was consumed by law.
Well,
Second of all,
let's pause for a minute, because I think I agree with you. I've read Mr. Bezdiga's appeal, the appeal that he filed in September of 2017, and he doesn't raise any issue about domestic violence. He does note that the SAFPD, when it issued its revised ruling, in its revised ruling said that the mother had claimed he was not attending the scheduled visits for purposes of psychological harassment, that he wasn't showing up, and that prevented her from otherwise scheduling activity with her children. But the revised schedule does not suggest that that was the basis for the SAFPD's decision, and he did not argue in the appeal that allegations of domestic violence had improperly influenced the SAFPD's decision. So I agree with you. That issue was not presented in the appeal for your court. I have a different question, though. I understand he brought this as an administrative review action in the court in Chișinău. And the trial judge, after holding a hearing in the spring of 2017, accepted as a fact that Mr. Bezdiga had not attended the the scheduled visits from October of 2016 into February of 2017. And for that reason, part of the trial court's conclusion was he had not shown that his rights had been denied because he had not exercised the rights he was afforded. And that was a basis for dismissing the challenge to the administrative action. It appears that that also was part of the rationale by the Court of Appeals. The Court of Appeals notes that at the end of its opinion. But again, you're looking at an appeal from an unsuccessful challenge to administrative action. So I take it the scope of the appeal is constrained by the nature of the challenge in the trial court, correct? The issue for the Court of Appeals was whether the trial court erred in dismissing the action to challenge the administrative decision.
The Court of Appeal, my opinion, and the rationale is that the Court of Appeal could not overturn a administrative act which was consumed. Let's say that the authority took as an action the arguments of the mother, but if you allow me, I would like to point out that the court at that time believed it necessary and documented very carefully, and due to the transparency within the program of cases handling, we double-checked all the details, and we found out that On 31 October, we on 31 October we examined that, and there is an irrevocable decision from 2015 when we actually rejected the appeal of the plaintiff. With regard to this case, therefore, we have documented very well due to the fact that we have a transparency in the integrated program, and we've also saw that there is a protection ordinance against the father. Therefore, in order to include in the final act those allegations with regard to domestic violence, we could not do that because nobody asked. None of the parties asked that. Second of all, the national legislator says clearly that you cannot exceed the limits with regard to a case. Nobody says anything with regards to domestic violence. And in this context, I would like to say that the decision of the Appeals Court from 1 November 2017 in no way affected the rights of the plaintiff, because we had an irrevocable decision with regard to the ordinance of the protection, which was maintained. And second of all, at that time, the plaintiff had initiated another process, and we also identified that in the integrated program of cases handling. Our levers, our legal levers, were not available because the court is obliged to protect the rights of the child for the future, and we cannot go back from that. Namely, from this reasoning, we issued a decision in this case. And again, I would like to highlight that that decision could not affect the rights of the plaintiff. It was an irrevocable decision from 5 of October. And second of all, he initiated another process with regard to the timetable. The case in our role the case in our disposal was only available for 2 months.
Understand. And I noted in the Court of Appeals decision, the Court of Appeals in the decision that you joined, and I think it was Judge Minchuna that that was the authoring judge. But in that decision, at the end, the panel acknowledges Article 8 of the Convention of Human Rights and the fact that there's a fundamental right to family life. I take it, do you accept that the decisions, that Article 8 is binding law for the courts in Chișinău or the courts in Moldova?
Of course they are. There is no doubt about that. We do accept that.
And I take it your view would be that the decision that the Court of Appeals issued is consistent with Article 8. In this circumstance, I've explained the rationale of the decision. It's a very specific case when the administrative act is being consumed at the date of examination. Otherwise, we didn't have our solution. But we are talking about a consumed administrative act. But of course, I do support and I totally agree with Article 8. There is no doubt about that. I totally support that. All right. I have no further questions. Do any of the other commission members? All right, Judge, we've come to the end of our hearing, and if you wish to make any other statements, this is your opportunity to do so.
Dear members of the Commission, I ask to accept all my arguments and the explanation I have presented on this subject. And at the same time, I believe that in this case, and the decision issued by the courts in Chișinău cannot be qualified as an arbitrary decision, because a judgment could be considered arbitrary when there is no basis, when there is no legal internal basis, when the circumstances of the fact cannot corroborate with the outcome of the procedure. Because here all the circumstances are being corroborated, and in the situation in which we can consider an error, there is no error in this case. And if we discuss about an error that could exist whenever a court could pronounce such a decision, there is no issue with regard to this case from this point of view. And I ask the Commission to retain everything I mentioned during related to this subject, and I believe those have been very well argued. With regards, and I wish very much that this exercise will be a unique exercise and a reversible one, and I count very much on the objectivity of the Commission.
Judge, thank you for your answers today and your answers to the prior questions from the Commission. After the hearing, the panel will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 252. The panel will strive to complete and improve its evaluation report and announce its conclusion as soon as possible. The hearing is now closed. Good morning to everyone. Thank you.
Vă mulțumesc.